Well, what do we mean by medical negligence? What is it?
In order to improve a service, any organisation needs to know what they're doing well and what they're doing badly.
Well, what's the average medical negligence payout? How much compensation am I going to get?
Will I have to go to court? Because most of them are terrified at the thought of going to court.
What does no win, no fee really mean?
So they will never be out of pocket, even if they're not successful.
One thing that one can say is that it's a lengthy process. Hello, welcome to today's episode of Medical Negligence Matters. And today we thought we would try and deal with some of the questions that we're most frequently asked about medical negligence litigation and the work that we do. And with me to answer those questions is my friend and colleague, Tami Frankel.
Hello.
Hello. So Tami, the first question is, well, what do we mean by medical negligence? What is it?
We're really talking about a doctor or whichever medical professional doing something or failing to do something that no reasonable medical professional of that sort would fail to do or would do.
So it's somehow departing from the normal standards of medical practice.
Yes, and there's a broad swathe of treatment that would be considered reasonable, from not quite suboptimal to gold standard, and all of that is reasonable, and it has to fall below suboptimal in order to actually be considered negligent so that you can bring a claim for any injury.
It's what sometimes people find difficult to understand, isn't it? Because, of course, medical practice is not all black and white. There are shades of grey, and there are a broad range of opinions as to right and wrong. And, of course, medicine is changing very rapidly. And so what constitutes reasonable and standard practice will vary, from...
Yes, it can vary over time, but it can also, just because the outcome has been poor, doesn't mean that the option chosen at the time, in retrospect, was the wrong option. At the time, you look at what was known at the time, what were reasonable options then, and as long as the option that was chosen was reasonable, the simple fact that someone has suffered, and we now know in retrospect that the other option would have been better, isn't enough to allow someone to bring a claim.
A poor outcome in itself isn't evidence of a claim, is it? So we have to prove, firstly, that there was some departure somehow from proper standards of care.
Yeah.
But the other thing, and I think this is in medical negligence cases often particularly tricky, is proving that failing in care somehow made the outcome worse than it would otherwise have been.
Yeah, because you're dealing with people who, by definition, have something wrong with them. They're ill, they have a condition, they've had an accident, and so there's already something going wrong to be dealt with, and so you need to show what is likely to have been the outcome if they'd have received different treatment.
Yes, so medical negligence, in summary, really is a departure somehow from the proper standards of care, and that departure somehow causing an injury that wouldn't otherwise have been suffered.
Yeah. Another question that clients commonly ask is, how is a solicitor going to assess the strength of my claim?
Yeah, that's an interesting one. I mean, to begin with, of course, the solicitor will really only have the information that the client can provide. And in many cases, that's quite limited, because many patients, when they come to us, don't themselves really understand exactly what has happened.
No.
I mean, specialist solicitors, of course, have a broad range of experience of similar types of cases, and so often one can use the experience that one's had in other similar cases to inform your assessment of how strong a case is. And I suppose that's one of the benefits of going to
a specialist,
a solicitor who specialises in the field. But I think having provided some preliminary advice about the prospects of success, what most solicitors then do would go through a 3-stage investigation process. And I think the first thing, and I think this is really important, is getting a statement from the client, sort of to put down in one document everything that they can remember about what happened. I mean, sometimes it's limited, but I think it's, as time goes on, and of course it is a lengthy process pursuing a claim, memories can fade, can't they?
Yes, no, you need to get your statement right at the beginning.
So it's important to get that prepared right at the outset. And then the second stage is getting a complete copy of all of the medical records. And that isn't always easy.
No, it's not as straightforward as people think.
And we have to get copies of all the medical records. And some clients find that a bit odd, don't they?
Yeah. Well, it is invasive. You've had, for instance, a broken leg, and we get the records relating to a termination of pregnancy 25 years ago. And so I see why people feel that way.
Yes, but it is important that when looking at one aspect of medical treatment, we have to be able to establish that there isn't any pre-existing injury or vulnerability which is relevant, which is why we have to have the whole medical history. So that's the second stage. And the third stage, and this I think is the most important, is to get reports from independent experts in the relevant clinical specialisms to advise us on the standard of the treatment that's been received.
Yeah.
And the key points here, I think, are firstly identifying the experts.
The expert, yeah. Both the specialism and the person.
Yes. And making sure that individual understands the legal tests.
Yes, yeah.
Because the way that clinical judgments are made is often quite different from the way that legal judgments are made.
Yeah.
And it's important for the experts to understand the legal framework that they're working in.
Yes, it's not just something you would or wouldn't do. It's something no reasonable doctor would or wouldn't do.
And a specialist solicitor, of course, also has to have that skill to be able to understand and analyse critically the advice that they're getting from the expert.
Yeah.
So you don't necessarily take it at face value. You need to be able to look at it and work out whether the advice that's been given is logical and consistent, and also whether it will stand up to scrutiny in a courtroom.
Yeah, and you may have previous experience yourself of similar cases that helps you to ask further questions of your expert.
So that's
the three
in outline,
things.
the fundamental assessment process, isn't it? So the next question I think we're often asked is, well, what's the average medical negligence payout? How much compensation am I going to get? That's a tricky one. Over to you.
I mean, I understand why people ask that. And of course, we're duty bound to give them a guesstimate at the beginning of any claim of what we think at that stage. It's really difficult to know how much someone is going to get.
There isn't an average, is there?
No,
because
there's no average.
Each case is unique. And
all we can do is describe to them the way in which it will be calculated, the difference between, well, the two aspects of compensation they'll get: general damages for the injury itself, and then reimbursement of all the financial losses and expenses which they've incurred up to date and which they're likely to incur in the future. And I think it's just, you can sometimes give them an idea because you may have an idea of general damages because of similar cases with similar injuries. And if they can tell you things like whether they've been able to return to work, you can have a guesstimate at loss of earnings and things like that. But it's no more than an educated guess within the limits of the information you've been provided at that time.
Yes, I mean, there are guidelines that are published about levels of damages for certain types of injury, restricted, of course, only to what we call general damages. That's the damages for the pain and suffering, physical and emotional. And I suppose a lot of people can do internet searches and sort of look these up for themselves. But of course, the damages in each individual case depend on the individual circumstances of the person who's been affected and their family circumstances, their career, their responsibilities,
age.
their age. So it's and that's the skill of a specialist lawyer to
absolutely
apply
to be able to put
all of those variables in coming to a figure.
Another question that clients often ask is, am I going to win my case? How likely am I to win my claim?
That is an understandable question, but it's a very difficult one to answer, certainly at the outset. And I think that the specialist lawyers will have a much better idea of the types of cases that are likely to succeed. But then we all know, don't we, that we've all come across cases which on the face of it look like real dead certs. But then as you investigate, things happen, the circumstances become more apparent, and a case that looked very good can turn into something
one difference between that case and a very similar case that succeeded can be the difference between success and failure. Yeah, absolutely.
Yeah. So it's very difficult at the outset to tell somebody what their prospects are. But I think that certainly when we're taking on a case, we would certainly say that if we're taking on a case, we think it is probably more likely to win than to lose.
Yeah.
But we can't say any more than that until we've got the evidence that we need to prove the things that we need to prove.
Yeah.
And so the prospects of success will change at various points as the case goes on.
I always tell clients, we constantly reassess the case with every new piece of evidence. What does it mean? How does it impact on the likelihood of success and the value of the case?
So it's something that's a constant process.
It's a constant process, yeah.
So another question that we're asked very frequently, and understandably because people are concerned about how they're actually going to fund their cases, is what does no win, no fee really mean?
Yep, no win, no fee really gives a client the assurance that if their claim is not successful, they will not have to pay a penny. So they will never be out of pocket, even if they're not successful. They also won't have to pay anything as the claim goes along, which is very reassuring for most people. There is potential to pay something if they're successful, but they will only pay something if they have been successful.
Exactly. So all they'll be required to pay will be something out of the compensation that they recover.
Yes.
They won't have to put their own hands in their pockets to pay for things up front.
Another question that clients often ask is whether they can claim against the NHS alone or whether they can also claim against other doctors, maybe if they've had cosmetic surgery, private dentists or other private healthcare.
Yes, quite. I mean, that's right. Medical negligence is not just involving the NHS. These days, of course, many people with private health insurance have much of their healthcare provided outside the NHS. And I think it's important to point out that the fact that the care is done in the private sector doesn't mean that there is no claim for medical negligence. And medical negligence covers NHS care, it covers private hospitals, it covers private doctors, it covers physiotherapists, cosmetic procedures. It's a very broad field. And providing that one can establish negligence by getting the appropriate evidence, then a claim can be brought against any medical healthcare provider.
The standard is the same, isn't it? So if you have your surgery on the NHS or privately, the standard of care is the same that you're entitled to expect.
Exactly. The legal tests are identical.
Is exactly the same. So yes, they can, wherever you had your care, if something's gone wrong, there's possibility of a claim.
Absolutely. And another question which I think is quite topical and makes some people feel uncomfortable is, will making a claim harm the NHS or the individual doctor?
It's a difficult one because in some ways you want to say, why would that even be part of your decision making to a client? But it is. They do think about that.
I think this is true, isn't it? I mean, I think that there is a lot of veneration of what now is regarded as our NHS, and there is a certain, I suppose, squeamishness amongst some people in thinking about bringing a claim against it.
Whereas I would say, actually, it's more likely to, or it really should, help improve the service. In order to improve a service, any organisation needs to know what they're doing well and what they're doing badly. And the NHS does collate data about claims. And I think if nobody brings claims to their attention, they're not going to know where they're going wrong. And we do see the same types of claims coming through.
I think that's true. I mean, I think perhaps what is underrated is the idea of accidents being a learning experience, certainly within the health service, and the opportunities for improvement in practice that can be taken from properly examining what has gone wrong and why.
Yeah. Because it's often not one person, is it? It's a bunch of things.
It's
systems.
It's
that Swiss cheese thing of all the holes matching up together, and it gives the organisation an opportunity to look again and see where can we put in something to stop this happening again.
Yeah, so I think patient safety is an important aspect of this.
Yeah. Sometimes in relation to individual doctors, though, clients, far from being concerned that the individual doctor may be harmed, quite want the individual doctor or person who's treated them or their loved one to suffer in some way. And of course, that's difficult as well.
It's tricky, isn't it? I mean, I think we can all understand the desire for accountability.
Yes.
And I think that normally comes from a place of people feeling, well, if you've made a mistake, you need to recognise that you've made it. You need to understand the consequences of it. And unless you do that, there's nothing to prevent you making the same mistake again. And I think that's I suppose so many of our clients say to us, I want to know that what happened to me isn't going to happen to somebody else.
Yeah, they all echo it.
And I think that as a firm, I think we try to give very clear advice to clients about the limits of accountability that the civil process can bring.
Yeah, the limits of what we can get for them, what we can do. Yeah.
Yeah, and I think it's important that clients understand that at the outset.
It is, yeah.
Oh, this is an interesting question, this next one. How long does a medical negligence claim take?
Oh, interesting and impossible to answer. I mean, there are so many factors that go into it. There are a number of stages that have to be gone through, and some of those take quite a while. So, for instance, the first step, I think you said earlier, is taking client's witness statement. We and they are in charge of the timing for that. The next step is to get their medical records. We're not in charge of the timing for that. And although the record should be provided within 30 days, they're often not. And we even in some cases have to make applications to the court for them. So obtaining the records can take a while. And the next stage is expert reports, obtaining expert evidence. We usually obtain the first report on breach of duty, what the clinician did, from someone who's in clinical practice now, which means they've got a lot of calls on their time already and they're fitting these cases in between it. Those reports can take 3, 6, 9 months or more to receive.
It's a very difficult question to answer, and there is one thing that one can say is that it's a lengthy process.
Yes.
And I think it would be unreasonable for anybody to enter into a clinical negligence claim without an understanding that they're in for the long haul.
Yeah, absolutely.
Because the steps that have to be taken in order to prove the case all have, unfortunately, inherent delays built into them. And although we can press on with things as quickly as we can, we're very often in the hands of other people.
Yeah.
In terms of progressing to the next step. And so I think that it's important for clients to have reasonable expectations at the outset about how long it might take. And we don't want to make false promises about how quickly a result can be achieved, because the quick result isn't necessarily the right result.
No, not at all. And of course, we also don't have any control over how the defendant behaves. So even when we are ready to send a letter of claim and let the defendant know the basis of our claim, it's down to that defendant whether they hold their hands up and make a reasonable offer early or make us go all the way to trial. And of course, that can be a huge difference in time.
Yes, but I think invariably we're talking about years rather than months for a clinical negligence claim, aren't we?
I think it would be very unusual to have anything more than a couple of years, less than a couple of years, yeah. Clients also often want to know how they can make claims on behalf of someone else, maybe their child or a spouse who's had a head injury.
Oh, yes, this is interesting, isn't it? I mean, we have touched on this in an earlier episode in this series, haven't we? But I mean, there are, in this country, in order to bring a claim, you have to have legal capacity. So that means you have to be over 18 and you have to be capable of understanding the litigation process and dealing with that. So children, those under the age of 18, and people with some either a brain injury or some other sort of genetic disability which prevent them from having capacity, have to have somebody to bring the claim on their behalf. And it's the title of the person who brings the claim is litigation friend. And I think specialist solicitors can explain what that really means in terms of responsibility. But
because it is it's a lot of responsibility to bring a claim for someone else.
Yes, because yes, you have to ensure that all the proper steps are being taken for that individual and that all their interests are being properly represented.
And you're bound for the length of the claim, really, aren't you? If you start it, you can't really back out and just leave it.
Yes, but specialist solicitors can provide all the support and advice that's needed
needs,
for that.
Yeah.
The next, and this is a very important point, is that not a lot of people are aware of this, but there are very strict time limits for bringing claims for medical negligence, aren't there?
Yeah, I mean, the most important one is 3 years from when the event occurred. But with medical negligence, that can be tricky to determine, especially if the event or the negligence is something like failing to request a test or something.
Yes, that's true, because sometimes the injury can manifest itself several years after the breach of duty. I mean, as you say, in cases like, for example, a failure to interpret an X-ray properly, I mean, it may be years before that it comes to light that has occurred.
And that there's been some harm as a result of it, in which case you have time limits based on when you knew that something had gone wrong and injured you.
Yes, and again, specialist lawyers can advise about the technicalities of that rule. But as you say, it's basically 3 years from the date of the negligence or from the date of the knowledge of your injury, if that's later. And of children, of course, if you're under 18, your time limit doesn't start to run
until you're 18.
Until your 18th
I've always thought it's weird we call it 3 years from when you're 18 rather than calling it 21. But it's like,
the effect is the same. So 21st birthday for children. And I suppose, and for those who have a sort of permanent mental incapacity, I mean, arguably the time limit never runs out.
I think that's why we say to anyone who's thinking about a claim, just because more than 3 years has elapsed, don't let that put you off making an inquiry. That should be a reason to make the inquiry as soon as you can. But don't let that put you off making an inquiry.
Exactly, because the lawyers will be able to advise as to whether there is any real prospect of being able to pursue that claim late. Yeah. Because the court always has a jurisdiction to allow a claim to be brought out of time in certain circumstances.
Yeah.
I mean, it's not a discretion that's exercised lightly.
No.
But if there are very good reasons why it hasn't been possible to
bring the
claim earlier, then it is possible to throw yourself on the mercy of the court, really, and to get that time
to have permission
allowed
to bring the claim. One of the other questions that clients commonly ask is, will I have to go to court? Because most of them are terrified at the thought of going to court.
Of course, no, and understandably. I mean, those of us who have spent time in courtrooms know that it can be a very stressful experience.
Okay.
And so I absolutely understand clients' concern about that. And of course, the answer is that in the vast majority of cases, no, you won't need to go to court, because most clinical negligence cases are settled well before it gets to that point. But what I always say to my clients is, well, no, it is unlikely that you'll have to go to court, but we will always prepare the claim on the basis that you will.
Absolutely,
because there's no other way really of making sure that your evidence is in the state that it would need to be to succeed in court.
Other than doing that. And of course, that also, the strength of your evidence is what will then help to persuade a defendant that actually they ought to settle your case, because we can all see what is likely to be the decision of a court. So it also helps to...
And I think the other point I'd make is that although it's really unusual to have to go to court, I think clients should feel confident that we would prepare them well for the experience.
Absolutely.
So that we would explain to them exactly what they can expect, what they would need to do, who will be there to represent and support them, so that it doesn't come as a surprise.
No, and we'll have a conference with the barrister and all of their experts beforehand. They will be supported.
Absolutely. So they're not alone.
No, they're
in that
not alone at all.
Sure. And finally, clients sometimes ask, well, what happens if the doctor's retired or moved abroad? What then?
Well, the truth is that can provide a problem if we're talking about private medicine in terms of who we even bring the case against. But if we're talking, so really there are two parts to that question. Firstly is, where will the defendant get their evidence from? But secondly is, if it is private, how will we have a defendant? And more these days, we're able to trace people and trace their insurers, because, of course, it's rare for someone to pay out of their own money for a claim that's made against them in clinical negligence or in anything. It's about insurance. It's about making sure there's an insurer at the back of it. So if somebody has retired, they should have insurance which was in place at the time.
So it would have covered them at the time that they were in clinical practice.
Whatever it is happened. And if they've moved, we need to trace them. And if we can trace them and find insurers.
Yes, a client having moved abroad can provide can raise technical difficulties for us as lawyers,
problems,
isn't it? But are things that are not insurmountable.
No.
Because it is possible to serve proceedings out of the jurisdiction.
Yes. Yeah.
It's something that we don't have to do very often, but it is possible.
Yes.
But it's very important to get good legal advice.
And it's important that's why you need specialists. We trace people right from the beginning. We make sure that we have a defendant for every client who is going to be able to pay out. Why take a client through years of stress to find that there's no one who can pay them their damages in the end?
Exactly. It's something we would look at the outset and say, so we're not going off on a wild goose chase against somebody for whom we'll never recover against. So we've covered an awful lot today, Tami, but thank you very much for your help with all of that.
Thank you.